All right. All right. All right, good afternoon, everyone, and welcome to this public consultation on the bills that we propose, namely the Firearms Amendment Act, the Electronic Evidence Bill, the Criminal Code Amendment Bill, and the Evidence Bill. What I propose is to... Is the bail amendment in it?
No. Should be.
Oh, I see. The bail, I thought it would have been included. Really, the bail amendment is a one-liner. What it intends to do is to alter the 24-hour period that the police can hold in detention and return it to the common law position of 72 hours. Well, it would be statutorizing the 72 hours holding period that the police have been used to. This has come about as a result of exchanges and consultation with the police regarding the prosecution of their investigations and how onerous this provision has become to them. And so we considered it best then to revert to the common law position of the 72 hours. No period exceeding that, because once you exceed that, you get into the murky waters of infringing liberty rights and that sort of thing. So the 72 hours is quite reasonable and universal. So we'll return to that. That's really what the Bail Act, the amendment to the Bail Act, seeks to do. So I apologize that it is not here before us, but it is a one-liner amendment in terms I just mentioned. I think to begin, I think to begin with, I'll indicate that certainly in relation to the proposals we have solicited the views of our colleagues in the profession, particularly in relation to the heavier items that we propose today. By heavier items, I mean the Evidence Act, or the proposed Evidence Bill, and the Electronic Evidence Bill. These are comprehensive reforms to the existing law of evidence in the territory. The other two amendments, that is to say, amendments to the Criminal Code and the Firearms Act in relation to gun-related violence and penalties, these they're important because of the reform measure we seek to introduce, but they are not heavy in the same fashion or in the same way as the other two, and I will speak to that shortly. What I propose is to allow Senior Parliamentary Counsel Serena Connor to run through in summary fashion, in her usual clarity, the other three bills, that is to say, 1, the Criminal Code Amendment, 2, the Firearms Amendment, and 3, the Electronic Evidence Bill, particularly because she was very much involved in these three. Okay, so Serena.
Thank you, AG.
No, that one is regulation. There's a regulation that will come. I saw the emails on that day. Who's doing that?
Kerry.
Coming shortly.
As AG said, I will be presenting on the Firearms Amendment Act and the Criminal Code, the amendment to the Criminal Code, and also the Electronic Evidence Act. In relation to the Firearms Act and the Criminal Code, the amendments came about as a response to the increase in gun crime. A hardline approach has been taken as a means of deterring persons from engaging in these activities. In relation to both the Firearms Act and the Criminal Code, we have identified different firearms offenses categorized into two, first being discharge-related offenses, and the second being possession-related offenses. And in relation to each of these categories, we have prescribed a minimum term of imprisonment that will be imposed in circumstances where a person is found guilty of any of these offenses. So first I will look at the discharge-related offenses and then at the possession-related offenses. In relation to the discharge-related offenses, the minimum term of imprisonment that is going to be imposed is going to be automatic and mandatory. So what is prescribed depends on the age of the person. So if a person is an adult, the minimum sentence that will be prescribed is a more stringent, a harsher sentence than would be the case for a person who is between the age of 14 and 17. So in this case, in relation to discharge offenses, where a person has been found guilty of discharging a firearm, the sentence that is prescribed will automatically be imposed. In relation to possession-related offenses, the presumption will be that the minimum sentence that is prescribed will be imposed in circumstances where a person is found guilty. However, the court reserves some discretion. In exceptional circumstances, if the court deems it necessary to divert from the minimum sentence as prescribed, the court has an option to adopt a more lenient approach by imposing a lesser term of imprisonment or a fine. Those are the penalties that are available to the court. In relation to the exceptional circumstances, the amendment specifies that where a person is a first-time offender, that would be regarded as an exceptional circumstance. And where the person is a first-time offender and he's an adult, the court, as I said, has the discretion to adopt a more lenient approach and impose a sentence that is lower than what is prescribed as the minimum. And where the minor is, where the person, rather, the first-time offender is a minor, the court has to revert to the Child Justice Act for guidance on an appropriate minimum sentence. Where the person is a repeat offender, as I said, the presumption will be that the court would look to the amendments for guidance on imposing what would be the minimum sentence in relation to the particular offense. That is, in summary, the amendments to both the Criminal Code and the Firearms Act. Any questions? Comments?
What does that mean? You have to use the microphone.
If someone is caught with a firearm. If someone is caught with a firearm at this time, it's left to the discretion of the magistrate.
The possession, if it's a possession-related offense, if they're a first-time offender, the court will determine if these fall within exceptional circumstances.
Right now.
Right now,
Oh,
at present.
right now.
We haven't done this yet. So
The
the position
The position now is what?
unamended.
unamended, there is, the court has the option to impose a fine or a penalty. Let me pull up the Firearms Act, because there are different possession-related offenses, so it would vary depending on the particular offense. But a person who is found guilty of an offense for which no penalty is otherwise, so this is a general catch-all, so they can, on summary conviction, so that means if they are found guilty in the magistrate's court, they can be subject to a fine of $200,000 or to imprisonment of 5 years or both. Or in the High Court, they can be imprisoned for a period of up to 14 years or to a fine, or to both.
So this means that the judge magistrate has discretion. They can be given a warning and sent home.
In this, yes, it
On
says
the
that,
present legislation.
yes, they have a discretion.
I believe the magistrate does have the discretion to reprimand and discharge.
Right.
Oh, yes, I believe that the magistrate does have the discretion under the current law to reprimand and discharge. That part of it has not been altered.
Right. So now, on the new legislation, if I am caught with an illegal firearm, what happens? First time offense, and I had an offense before. What? First time offense, but I had an offense before that is totally unrelated to guns. What happens to the first time offender who has a record, who has now is caught under the new legislation that's being proposed?
Yes, if you're a first-time offender, the amendment here deals with persons who are repeat offenders in relation to firearm offenses. So if you're a first-time offender, the court has the discretion to determine what would be the minimum what is the appropriate sentence in the circumstances.
This does not.
In short, he'll be treated as a first-time gun offender.
This does not have an impact on someone as. If you compare the old legislation to the new legislation, first-time offender on the old legislation, the first-time offender on the new legislation, this does not impact that position.
No, if you're a first-time it's only if it's in relation to a discharge offense.
Right.
So if it's a discharge offense, a hardline approach has been taken. So the mandatory minimum will be imposed if you're a first-time offender. If it's a possession offense, which is what you asked for in the first instance, the court has the discretion to impose a more lenient sentence than what is prescribed in this amendment.
Okay, I think I understand. But if it is a discharge situation, then
Which is a more serious offense.
Under the old legislation, what is the difference between the old legislation and the new legislation if it's a first-time offender discharging the firearm?
In the old legislation, there's no special treatment with regards to whether or not you're a first-time offender. The court exercises its discretion in accordance with whatever the provisions are in relation to the particular offense. So what is prescribed is in terms of what is available to the court, whether it's a fine or a term of imprisonment, depends on the particular offense.
And no.
And now, if you've discharged a firearm, whether or not you're a first-time offender because it's a serious offense, what is prescribed as the minimum will be what will be imposed.
And what is the minimum?
It varies depending on what the particular discharge is. We have several discharge offenses.
Okay. It'd be good if you can expound on that a little bit.
You want me to explain different types of discharge?
Just for persons to understand what is the difference and what are the minimum sentences.
Oh, in terms of the discharge.
I think it's critical to understand that on the law that stands now, there is no differentiation between first-time offense and discharge offenses or possession offenses. The amendments that we introduce now seek to treat with the two categories with differentiating seriousness. So the discharge offense, as my colleague calls it, is when you use the firearm in perpetrating some offense or you just set off a shot or two or many, you're using a gun. So you could see the increased risk to harm to persons in the public, not just the target, surrounding circumstances and surrounding people. So that is more serious and merits a condign response in terms of the criminal law. But the possession is something dealt with differently because of the nature of the possession offense itself. People can come into possession in different ways. I mean, you could have a gun lying around and at the time of the search, your 36-year-old cousin is in the house, and under the constructive principles of possession in the criminal law, on the surface, possession is fixed on him. You see? So we need to approach that one a little bit more probity than shooting off shots.
So I've identified, for example, an example of one of the discharge offenses in the Criminal Code is Section 216. A person who unlawfully discharges or attempts to discharge any firearm at any person or being armed with a firearm unlawfully threatens to discharge such firearm at a person commits an offense and is liable in addition to any other penalty for an offense he thereby commits to imprisonment for 5 years. So the court has the court can imprison him for up to 5 years. In relation to this particular offense, the minimum sentence that is prescribed in relation to an offender who is 18 years or over is 3 years, and in relation to a person who's between 14 and 17 is 1 year.
What's the interplay between that 14 or 17-year-old and the Child Justice Act?
The 14 and 17-year-old, where a person who is between 14 and 17 years old, if they are a first-time offender, you'll revert to the Child Justice Act in relation to possession-related offenses. But where the person is, where it's a discharge-related offense, the minimum sentence that is prescribed here would apply to act as a deterrent. This is a more serious offense, as AG explained.
That's the idea.
Good evening. Yeah, one of my questions would have been about how minors would be dealt with under the law, and it seems this new amendment seems that if they're a first-time offender, then they can be looked at under the Child Justice Act, but if they're repeat offenders in terms of firearm discharge, then they're treated under the current amendment. I have a question about, say, a gun is found in a home where there are minors. What is the liability of the parent or the owner of the home if they're not the one that, say the gun is not theirs, but the gun is found in their home? How is that treated?
Well, the offense there would be possession in relation to the responsible adult in the premises, the house. Of course, under the amendments, we'll have to also look to see if the other indicia, the other things are present, which is whether the person is a repeat or whether it's first time. If the person is first time, then
First-time offender in possession, they will be treated under the Child Justice, if it's a minor.
not the minor,
The
the
adult.
adult.
First time you would revert to, the court has a discretion to impose a sentence that is lower than the minimum term.
But in those circumstances, because it's aggravated, you have possession with a minor's lying around, a gun. It's up to the court to see how the court treats with that in terms of the range of the sentence.
But I want to look at it the other way. The adult is not the perpetrator. The perpetrator is actually the minor, but the gun is in that house that is owned by the parent. How say that the gun is now found and it's tested and it was involved in a shooting incident. Who is held liable? Is it the parent or the minor? How do you determine? How would the police be instructed to deal with that situation?
Well, if the firearm was associated with perpetration of an offense and it's linked to the minor, that will engage the criminal prosecution process. We'll have to look at factors such as the age of the minor. If the minor is one of those persons that would be caught, 14 to 17, they'll be caught under the Child Justice Act. So there will not be any peremptory or automatic sentence that would fall on the child. Child will go through a different process under the Child Justice Act, the diversion processes and that sort of, which are non-penal,
No sentence of imprisonment, yeah.
there would not be the usual process, in other words, that would normally engage the adults. And if the child is of a different age, 18 and over, then they would be caught by the usual processes, including this amendment, and they would be liable to the prescribed minimum, which would, especially if they are first time.
Right.
That would be, and the discharge, because if you're talking about an investigation where the use, discharge of the firearm, you have GSR evidence and all that sort of thing, then you find yourself caught within the 1 year prescription.
Right.
1 year?
It depends on what the particular discharge offense is.
Yeah.
So
Yeah.
the one I explained, it was 1 year.
1 year.
Yeah. I just wanted to be clear that, you know, if a weapon is found in a home, that, you know, there is some liability for the homeowner.
The
even
concatenation
if
you
they're
gave
not-
is more of not just possession, but discharge. It was used
Yes,
in a
correct.
in perpetrating an offense. So that's
Right.
all the more serious.
Yes,
Yeah.
okay. Thank you.
Let me see now if I remember this one now. Okay.
My engineer friend.
That's right. Photographer. Yeah, that's it. In times past. Okay, I want to know the difference between the parent or the adults in the house knowing about the weapon being in the house, and if they don't know about it, what difference it is. How can you determine what penalty will be imposed upon them if they know, or if they are aware that the weapon is in the house, against if they don't know it's in there?
Well, we're largely dealing with possession, which is really something that is constructively determined. And by constructively determined, I mean by a matter of physical observation and physical circumstances having been observed. So these amendments don't necessarily seek to distinguish what is, or to determine what's in somebody's mind as such. You have a set of circumstances that may confront the court. And what the amendment says, if possession constructively determined in relation to an adult or first-time minor offender or repeat minor offender or repeat adult offender, then these penalties would apply if they are found guilty. That's all it seeks to do.
Okay.
The trial process will determine all these other things as to whether the adult really was in possession, as the chief said, whether it was the kid or whether it was the parent.
Oh.
This just seeks
So then
to apply the punishment.
The court will determine.
The court will determine that. Now, and as we're on this, I think it is opportune now for me to say this, to make it clear. These amendments are not just thrusting things upon anyone. These amendments, what they do is that if the net that the court casted was at this wide, it just shrinks it a little bit. Because of the seriousness and the prevalence of these offenses, we're saying rather than having a wide discretion, because we know circumstances vary, the discretion is still there. It is still there. What happens to the discretion by these amendments is just limited a little bit. It is constrained a little bit so that a message, a signal is sent as to the seriousness of these offenses. So, back to the scenario. So we're not too concerned in these provisions with distinguishing people's mental state and that sort of thing. The court will do that in the process.
Okay.
If you go through the court process and you had a blameless mental state, then these provisions don't get involved. If you are blameworthy, then if you fall into one of the categories, a certain minimum must apply to you. There could be more, it could be a maximum, but a certain minimum
right.
must apply to you to signal the importance and the severity of these and gravity of these offenses.
Okay. And when do these amendments go into effect?
Or when they're passed by the Parliament, Chief is the leader of government business. I mean, I rely on his timing is pretty speedy. So we expect that to be soon, before year end. So we will start 2024 with a serious thrust in terms of the administration of justice.
And practically, you are convinced that these amendments will help to deter or mitigate crime to some extent?
Of course, I think so. I think we must remind ourselves that there is no perfect system.
Mm-hmm.
What you want is a justice system that is fair, but you want a justice system that is firm as well. If it is not seen to be reflective of the collective conscience, and by collective conscience I mean the sentiments of the community, the shock and horror of the community, and the prevailing views of people in the community by and large as to what should be an appropriate response in terms of punishment, then your system fails you. But I think this is an appropriate measure, and it is one that is not a knee-jerk measure. There was a parliamentary subcommittee on it, and it was a deliberative discussion, an evolving one, but deliberative. And these measures were produced in tandem with that. So I think it will go some distance in
So they were
addressing the situation.
reviewed and examined and
But of course,
inspected.
yes.
All right.
Well, remember, these are penal measures, and I think I want the public to understand that penal measures are what I call measures that come more or less at the back end. It's really a response to things that haven't already occurred. The address to violence, particularly gun violence, is a multifactored approach. You know, there's a social welfare aspect to this. There's a familial aspect to this.
Proactive
because
measures.
Most of these youngsters come from home. So I mean, there is a holistic approach to it, but that does not mean that on the side of the justice system, nothing must be done. Of course, there must be a response, and this, so far, we think will go some way in addressing the issue.
Thank you, sir. Thank you, ma'am.
Good afternoon again. This is a question from one of the viewers, Jason Richardson. The question is, if a person has committed an offense before the amendments are enacted, but is tried after the enactment, will they be charged under the penalties of the time of the incitement or the time of the trial? So basically, you understand the question?
So you can only be, the penalty that will be imposed would be the penalty that existed at the time when you committed the offense. Cannot retroactively punish someone. You cannot put someone in a worse-off position by the passing of legislation. Okay.
All right, I think we can press on. If there is no other commentary or question, it's been pretty good questions so far, man. Very good. I think we can press on to the Electronic Evidence Act.
Okay, so the Electronic Evidence Act looks at the admissibility of evidence that is in electronic form. This particular act deals specifically with admissibility of evidence as it relates to the best evidence rule and authentication of information that's in electronic form. As it relates to other rules of evidence, any statute dealing with evidence, such as the one that the AG is going to present on, and any common law, those two would apply in relation to admissibility, rules of admissibility in courts. So in relation to the best evidence rule, it is where there's legal proceedings and you're seeking to admit into evidence information that's in electronic form. This information is admissible where the integrity of the computer can be proven, and this can be proven in numerous ways. Firstly, if you can demonstrate that the computer that was being used to generate the document was in good working condition, and even if in instances where it's not in working condition, if you can demonstrate that the information stored on the computer was in no way compromised, that would be sufficient for improving the integrity of the computer, and therefore the best evidence rule will be satisfied. Similarly, where a document is produced in the ordinary course of business, and the person who actually generated the document inputted the information that resulted in the record being created. If that person is unrelated to any of the parties to the proceedings, that information is admissible and will satisfy the best evidence test. And And lastly, if the person who actually produced the document has an interest that is adverse to the person who's trying to rely on the document, that would be sufficient for satisfying the best evidence test. So that is in relation to admissibility of information that's in electronic form. In relation to statements that would otherwise be treated as hearsay and therefore inadmissible as evidence of facts that are stated therein, the information that is in electronic form, the statement that's in electronic form could nevertheless be admitted if the best evidence rule again is satisfied and you can demonstrate the integrity of the computer. And it can be done in the same 3 ways that I explained earlier, or if the court can also engage an expert to verify or authenticate the evidence or the information in electronic form. If you can demonstrate that the information was stored on a device that was incapable of being altered, that too would be sufficient. And the information that's in electronic, the statement that's in electronic form would be admissible. This act also deals with printouts. So if you have a printout of information that's in electronic form and it's relied on, then the best evidence rule is satisfied here, and therefore the information that's in print form can be admitted into evidence. It also recognizes electronic signatures. So if the law requires a signature, or if the law has ramifications for the absence of a signature, if you have a signature in electronic form, this can be legally enforceable. Also, in relation to electronic evidence or electronic signatures that originate in a jurisdiction outside of Anguilla, if you can demonstrate that the means of authenticating the documents in the jurisdiction outside Anguilla aligns with ours, then that information would be admissible in courts. And if the information is not physically present in Anguilla, if there is in existence a treaty of some form between our jurisdiction and that of the jurisdiction where the document is coming from, that recognizes the electronic signature or recognizes the electronic evidence, then that will be sufficient, and that information will be able to be admitted into court. So that's it for the Electronic Evidence Act. AJ, I don't know if you have anything to add.
Only to say that, in a mouthful of English, that the Electronic Evidence Act is intended really to bring the law on evidence up to date in a modern fashion, to be consistent with the improvements with technology and technological instruments. As you know, some countries are even moving to paperless transactions, particularly in money. Some parliaments are paperless now. And so the concept of a document is now reimagined, and it's not what it used to be under old law. So the Evidence Act is to make it comprehensible in the modern context, and so that the mere electronic nature of a document or a signature or a footprint of some kind will be acceptable more readily in evidence, almost as the physical paper used to be in the past. That is the main objective of this.
You mentioned computers, right? But I didn't hear you specifically mention tablets, cell phones, and so forth. Do they apply?
Any electronic device. It's in electronic form. Any document or record that's in electronic form, however generated.
Okay.
If there is, if there isn't anything further, let me just briefly address the Evidence Act now. The Evidence Act is, well, there exists an Evidence Act here in Angolan territory, of course. As a piece of legislation, it is not very extensive, and it is rather old. Old in time and old in its comprehension of what constitutes evidence and how it is authenticated. The evidence bill that we intend to pilot, we propose, will do the following. It will introduce a comprehensive code for what constitutes evidence for the purposes of proceedings in court, both the criminal and civil courts, as well as authentication for the purposes of general documentary approval. Second, it includes and it upgrades the Evidence Act in another very important respect, in that it brings into being in Angola what we call admissibility of first-hand hearsay documents. I'll explain it now momentarily. It's connected to something that the Electronic Evidence Act does in a very broad way. First-hand hearsay would be a document, not necessarily an oral statement, a document that's generated, like the chief is writing something there, and his signature is specific, and there's a date of his note here. But that physical paper now under law as it stands now, it's not admissible in proof of anything in his absence. So if he writes about the fear that he has of someone in the room who might attack him, and he makes a note of that, and then he dies, in the present law we can't use that. If he makes that note on his WhatsApp, under the introduction that we're making here now, the printout after his death, contemporaneous with the time he dies, can be used in court as proof of his fear, and depending on the circumstances, proof of the person he states in there that he fears death from. You see? So it affords documents generated by computer or computer instrumentalities to become evidential in the absence of the persons who made them by means of these electronic or computer instruments, largely computer generated. So, for instance, in section 39 onwards, it gives you a very clear idea of that. And let me just, by way of illustration, take you to it. This is what section 39 says. Yeah? It speaks to criminal proceedings, both criminal and civil. I'll do the criminal first. In any criminal proceeding, a written statement by a person shall, it's not 39, but 40, subject to section 43, a statement made by a person in a document shall be admissible in criminal proceedings as evidence of any fact of which direct oral evidence by him or her would be admissible if it is proved to the satisfaction of the court that such a person, A, is dead, B, is unfit by reason of his or her bodily or mental condition to attend as a witness, C, is outside of Angola, and it is not reasonably practicable to secure his or her attendance, D, cannot be found after all reasonable steps have been made or taken to find him or her, or E, is kept away from proceedings by threats of bodily harm, and no reasonable steps can be taken to protect the person. Admissibility in civil proceedings, subject to the same section 43, which I'll come to briefly the same can be done. The party intending to tender a statement of evidence shall not be obliged to call as a witness the person who made the statement if it is proved to the satisfaction of court that the person is dead, is unfit, the same kinds of criteria. We go on now to computer evidence, which is otherwise the hearsay evidence. This is what it says in 43. Because remember I said everything was subject to section 43. A statement contained in a document produced by a computer which constitutes hearsay shall not be admissible in any proceedings as evidence of any fact stated therein unless A, at all material times the computer was operating properly, similar to some of the things that we were told. Computer was not subject to any malfunctions. There were no alterations to the mechanisms, etc. And then there are some documents generated from the computer that do not constitute hearsay. 44, where a statement contained in a document produced by a computer does not constitute hearsay, such a statement shall be admissible if the conditions specified in section 43 are satisfied in relation to that document. One of the other things that the proposed amendment does, well, not amendment, is a complete repeal and replacement as part of the comprehensive evidence code we intend to introduce, is that it accounts for certain developments in the law of evidence that has taken place in Commonwealth countries and in the United Kingdom long since the original Evidence Act in Angola had been enacted. So it's really an update. For instance, there's provision for witnesses, particularly dumb witnesses, etc. For instance, again by way of illustration, section 1, well at this time it's called a clause, clause 131 of the bill, as to who may testify. First and foremost, section 130, we'll come to 131 in a second. All persons shall be competent to testify unless the court considers that they are prevented from understanding the questions put to them, or from giving rational answers to the questions by tender years, extreme old age, disease, whether of the body or mind, or any cause of the same kind. Section 131, provision for dumb witnesses. A witness who is unable to speak may give his or her evidence in any other manner in which he or she can make it intelligible, as for example by writing or by signs, but the writing must be written and the signs made in open court. Evidence so given shall be deemed to be oral evidence. Now, there's a touchy area of the law which requires a statement in very clear terms, because a lot of it in this jurisdiction has been dealt with on what they call common law principles. That is the interplay between husband and wife and what matters can be proved in connection to the statement of one or the two, and the competence of one to give evidence against the other. Competency as witnesses of parties to civil suit and their wives or husbands. Section 132, clause 132. In all civil proceedings, the parties to the suit and the husband and wife of any party to the suit shall be competent witnesses. Subsection 2. In all criminal proceedings, every person charged and the husband or wife of such person shall be a competent witness for the defense at every stage of the proceedings, whether the person so charged is charged solely or jointly with any other person. Of course, there's a proviso which lists a number of conditions for an exception to be made. Importantly also, in this comprehensive code we intend to introduce, another one of the developments in the law of evidence that has been accommodated and to be simplified by this code is the issue of live links, given evidence by live links. there were some amendments made during the COVID time for that to be done. COVID forced us to have to do that because the ubiquitous nature of the disease and the constraints in having interpersonal and interface in courts and other meetings. But the present formulation of the procedure for that in Anguilla requires the Executive Council to be involved in the process of granting permission for facilities to be used and for the court to make an order for a live link hearing. Of course, that is intuitively inappropriate for the executive to be having a say as to the conduct of the court processes and proceedings. So we have altered that. Section 182, it rests squarely and solely with the court. Beginning from section 1, or clause 181, forgive me for saying section, I always deal with actual law. This is a proposed law, so it's clause. Clause 181, the court must make appropriate use of electronic communication or other technological advances to ensure that the matters are dealt with fairly and expeditiously, including email, fax, electronic meetings, what we know as the Zoom meetings, Zoom hearings, Teams, teleconferences and live links, and in this regard, the court must, wherever possible, deal with matters without requiring the physical attendance of parties at the hearing. Subclause 2, where a written document, record, or information is required to be submitted to the court, that requirement may be met by submissions made in electronic form. The court may, for the purposes of proceedings, direct or allow a person to make a written or oral submission or submission by way of live link or other appropriate technological means. I mean, I'm sure my colleagues at the bar would be happy with that, because I know there was some liberty in doing these things because of COVID, and when the COVID was lifted, the court headquarters in St. Lucia required things to return to the normal interface. This still gives the court some flexibility, certainly in Anguilla, if it conduces to more efficient administration of justice to hear parties by electronic means. The court is by liberty of this law, which is a domestic law, to do so. 182, live links, criminal proceedings, no more EXCO involvement. 1, notwithstanding subsection 3, a witness or other, well, a witness other than the accused may, if the court so directs, give evidence through a live link in criminal proceedings. Subclause 2, a direction may be given under this section. Remember the court, if the court considers. There's no executive process anymore. A direction may be given under this section A on an application by a party to the proceedings, or B of the court's own motion. So if the court figures, if the court believes that live link is most appropriate, even though no party has applied for it, because a critical witness in this gun offense lives in Birmingham, and I'm satisfied that arrangements are there for him in a secure location to give his evidence, I can order that, and that is completely a judicial exercise. No more executive arm of the government participation. I want to mention one other things, one of the other things here. The streamlining of, and the streamlining of and fulsome explanation, it's a detailed expression of means by which witnesses are to be examined in proof of facts in court and other proceedings. Now, people always think of evidence in terms of just the court. But if you have a disciplinary proceeding, whether on your job in the private sphere or in the civil service, where there is one of those proceedings under the public service regulations or general staff orders, evidence is evidence, you know. It don't necessarily have to be in a courthouse, because evidence is any relevant material that is capable of proving or disproving something that is in contest or dispute between people. So there is a detailed area or division of the new proposed Evidence Act that addresses that in complete fashion, namely in relation to order of the production and examination of witnesses, how the court deals with admissibility of evidence, the examination in chief of witnesses, orders for persons to come to be examined, cross-examination of persons in relation to documents and the production of documents, witnesses of character, etc. Now I want to take the opportunity, because I don't want to detain you any further, because evidence is a very cumbersome thing, because it's both a matter of law and it's a matter of procedure, to mention a few things. I think it would be remiss of me if I do any kind of summary of what we propose in this act without making reference to comments of my colleagues. The formulation and conception of these reforms are not something that was recently undertaken or hastily contrived at all. The first iterations of the two bills, that is the evidence bill and the electronic evidence bill, came into being since March, April of 2022. They were sent to colleagues for a sounding, and colleagues gave us very useful and insightful feedback. And as a result of this, I want to place on record that further to some of the interventions that our colleagues have made, we have actually made adjustments to the documents that you have before you. Those adjustments are in relation to the things I would now itemize and refer to. Namely, our colleagues were not sure and were concerned about the purpose and fit of what is in the bill as clause 65. That is a clause that deals with character as affecting damages. Colleagues felt that that would be a useful clause in relation to claims of defamation, but were unsure as to how it related to other aspects of proceedings, because the clause merely says characters affecting damages. In any civil case or in civil cases, the fact that the character of any person is such as to affect the amount of damages which he or she ought to receive is relevant. One of the things I should mention before I explain this is that in this new Comprehensive Evidence Act, there are explanations at the bottom, so that quite apart from the usual objects and purpose of the bill that's read in the House to introduce the bill, when it is passed, it actually has its own footnotes and explanations. In short, the new Evidence Act will be its own lexicon, its own dictionary. It explains itself. And you look at the footnotes below. In relation to what I just mentioned about characters affecting damages and my colleagues' concerns, the issue of character goes just beyond its relevance in the case of, let's say, something like a defamation claim. Character really includes your reputation and your disposition. So it is relevant also when one comes to misfeasance in public office, let's say, the abuse of power by a public officer and how they use the office to injure someone in the public. It comes up, and as a lawyer I can tell you, it comes up in negligence. So for example, chief is a duck. There was actually a case in the United Kingdom, in England and Wales, decided by the Court of Appeal of England and Wales, regarding a surgeon who performed, I think it was a hip replacement or one of those surgeries. And he had done a stream of them in close proximity with the surgery upon this lady, and there were similar errors in terms of reattaching a muscle to a bone or failing to do so. And the question was whether those similar incidents, what we call similar fact evidence, was relevant to the issue of liability and damages, whether it was an aggravating factor. Now, the similar fact evidence was character evidence, because if you have evidence of a pattern of behavior, whether it is laziness, incompetence, negligence, that can be an aggravating factor. Aggravating factors increase, give an uplift in damages. So this is the real reason for that clause 65. It's not as narrow or narrowly confined to just a defamation claim. Another one was in relation to birth during marriage as conclusive proof of legitimacy and those things. We have removed that because we have other existing statutes in Angola that have removed the differentiation at common law between inside and outside child and illegitimate and all that sort of thing. Those things no longer need any special provision because there's standing legislation for that. So quite agreed with our colleagues, and we have removed that from the drafts. We have also altered the presumption in relation to a boy of a certain age being able or capable in law of committing rape. Under the Child Justice Act, I think 12 years and under, you are deemed not capable of certain kinds of crime. So 12 years and under, you should equally not be capable of rape. So it stands to reason. So we have made that adjustment. Another controversial area would be professional communications. And this requires my address in closing. It was a legitimate concern for colleagues, and some adjustment was made. In relation to what we have as clause 139 to 142, it addresses, seeks to deal with communication in a professional context, namely with lawyers, between lawyers and clients. First and foremost, what it does, it affirms the respect for attorney-client privilege. It does so in section 139, I think. In 138. It does so. However, what the provision seeks to do is that the professional attorney-client privilege, or legal professional privilege, LPP as it's called by lawyers in shorthand, would not arise, there's a proviso, would not arise and would not protect from disclosure any communication which was made in furtherance of any illegal purpose or activity. And this is not an introduction of anything new, because attorney-client privilege at common law does not cover communication of an intended illegal purpose. In other words, it does not cover communication to enable a crime to be done. That does not conduce to the public good. So that no such principle of law exists. So it's really to statutarize it, to put it beyond doubt. There were some other provisions that were put in there at a time when we were dealing with the Proceeds of Crime Act, and so they were mirroring some of the provisions of the Proceeds of Crime Act, and colleagues felt that they were a bit too intrusive and onerous, and I tend to agree, and so they were taken out from it. But all in all, the proposed evidence bill is a comprehensive code, replacing the Evidence Act of Anguilla and introducing a complete reference for what is evidence, how it is to be proved, and to introduce flexible means of electronic hearings and electronic means of proof in Anguilla, consistent with modern developments in technology. Thank you. That's basically it. So any questions, we'll be happy to take them on this and any other bills that we presented on. If you omitted to ask something, you forgot something, you have a last-ditch chance to have a go. Thanks.
if I would, I'll ask this question. I think Minister Hughes referred similar to it earlier. But currently there might be unsolved murders that has not been, taken care of. What if when these murders become solved, more or less, which law would apply, the old one or the new one?
Interesting question. It is difficult to say. If we pass this now, but you see, a number of things will come to bear. It will be whether we can, at the late stage, when all the proof is gathered to a satisfactory level, whether we can sustain a prosecution as a matter of fact. The proof is, yes, it's part of it. It's a key part of it. We'll have to make that determination.
Right.
But if we pass this tomorrow, it will apply to any ongoing criminal proceedings. So if there's a case that had started last Monday, this will become the law for that case.
Okay.
Because this deals with how do you prove things in the court. It doesn't, well, to the extent that there are things that it deems to be evidential, like computer-generated stuff. Clearly, if there was some footprint off of a computer, an old IBM that modern technology could just now lift,
Right.
that would come within the context of this law, it may not be used because that was existing as evidence
Then.
at that time. This can't make it evidence retrospectively. So it's not an open and shut question. We have to look and see what it is that becomes evidence and how it can be proved to see whether this would apply to it. But certainly, as a matter of practical approach, if this is passed in the morning, it will apply to all proceedings in the court, current and future.
Thank you.
Well, Chief, I want to thank you, and I want to thank all who attended in person and those online for insightful questions. And I know every time I'm in a public forum, when the Chief is there, I know I'm going to get a penetrating question. I know he's very, very keen on that, and I know he has been keen on making sure that we get a legislative response that is not knee-jerk and wild and just, hysterical, but one that is well thought out, and one that can be evenly applied and fairly applied. And I want to give the assurance too that this is not set in stone, Chief. We are responding to the community. We are responding to you as their elected representatives. And if, as we go along with these amendments, they need tweaking, they will be tweaked to make sure that justice is served. But again, I also operate by the caution, and I've said it before, even in Parliament in open session, that I am not one keen for just bringing something to Anguilla because somebody else has it. We have to make sure that it fits and it works. So this is a work in progress. We've had public consultations on gun violence, and let's see how we can get the measures working. Thank you very much. Well, I want to say thank you to Serena and the drafting department for human service. I can't do it without them, and certainly I can't do it like them.